Thanks everyone for joining in today. I just want to welcome you and thank you for coming. Today's webinar is intended to be both an introduction to the current proposed changes to the next edition of USPAP and an invitation to you so that you can join in the conversation by hopefully submitting your comments to the appraisal standards boards as they consider future revisions. To start off, I first want to welcome Wayne Miller. He is the current chair of the Appraisal Standards Board, and he will be presenting the information today. Wayne, would you like to say hello?
Hello, Lisa. It's a pleasure to be with you today, and I'm glad you're having a lovely day in Colorado.
Thanks, Wayne. I will be presenting, I'll be just hosting today, sorry. I'm the Vice President of Appraisal Issues here at the Foundation. I just want to run through some real quick webinar logistics before we get going. We're going to be recording the webinar today, and it will be posted on our website and on our YouTube channel shortly after it concludes. Time permitting, at the end of the presentation, we will hope to answer some of your questions. And if you want to ask a question, you can simply enable your chat feature. All you have to do is move your mouse to the bottom of the screen, and then a little menu pops up. Click on the little chat feature button, and then the chat box will open. Or you can also use your keyboard shortcut of pushing Alt+H, and it will just pop up. Links to today's presentation will also appear in that chat box, so keep an eye on that. And finally, at the very end of the webinar, you will have a survey that will pop up, and it will just ask you a very few quick questions so that we can both understand your experience today and so that we can accept any suggestions you may have for improvement in the future. Our agenda for today is as follows. Wayne will explain a change in direction that the Appraisal Standards Board has taken between the first exposure draft and the second exposure draft. And then he will discuss the proposed changes to the requirements for Standards Rules 2, 8, and 10, signing the certification, a proposed change for the scope of Rook rule, some of the definitions, and a couple other minor edits. So our first topic is regarding reporting options. Wayne, can you explain some of the background rationale for the changes being proposed to the reporting standards 2, 8, and 10?
Certainly, Lisa. As you know, the ASB has been discussing the possibility of moving to a single set of minimum reporting requirements for some time now. It's no secret that a primary reason the ASB has considered the single reporting requirement issue was to solve challenges that real property appraisers faced when trying to complete an evaluation for a financial institution. Now, there are other reasons, but that has really been a dominant issue. Everyone knows we had a hearing last year on this matter, and we've put out some sample evaluation reports. So this has been an area of focus. A single set of reporting requirements was proposed early on, but was not adopted during the last cycle of USPAP changes. However, after adoption of the changes for 2021, the ASB informed stakeholders that we would continue to study the issue. So the first exposure draft of proposed changes for this cycle included wording that would accomplish two things. First off, it would eliminate the current appraisal report, that's big A, big R, and restricted appraisal report, big R, big A, big R options, in favor of a single set of minimum reporting standards. And secondly, it would eliminate the requirement to label the report as an appraisal report or a restricted appraisal report. Now, the ASB receives feedback from stakeholders through many channels, including direct comment letters in response to exposure drafts like this, verbal and written comments from the Appraisal Foundation Advisory Council, the Industry Advisory Council, sponsors of the Appraisal Foundation, the personal property and business valuation resource panels of the Board of Trustees, as well as comments and questions posed through the chat feature during webinars such as this. Now, real property appraisers and other stakeholders who are focused on the evaluation issue as well as those in the business appraisal discipline who use different labels for some of their work, favor the concept of losing the required appraisal label. However, when it comes right down to it, a significant number of appraisers only produce appraisals, and they do so for clients who only want to receive appraisals. And further, many stakeholders we have found are in favor of retaining two sets of minimum reporting standards, a regular appraisal report, if you will, with the option to provide a primarily results-only restricted presentation when something less than a regular appraisal report is appropriate, given the intended use and the intended users. And this second exposure draft offers proposed changes that the ASB hopes will keep both camps happy.
Can you give us a quick overview of the changes that are proposed to the reporting standards in this exposure draft?
Certainly. Well, slide 7 is up here on the screen. I'm not going to read it to you, but there are three main areas. Modification of the requirement to label a report, some rewording to introductory paragraphs in standards rules 2-2, 8-2, and 10-2, and rephrasing of the comment to standard rules 2-2 and 8-2 regarding circumstances under which a recipient becomes, or more importantly, does not become, an intended user.
Okay, thank you, Wayne. Now let's get down to the nitty-gritty of the details. What changes exactly is the ASB proposing with regard to the requirement to label a report?
Well, again, I'm not going to read this fairly dense page of text to you, but the first thing I would like to point out is a portion of the comment at the beginning of all of the reporting standards, which reads, "The substantive content of a report determines its compliance." With setting the stage with that, the ASB actually proposes wording in standards 2, 8, and 10 that would give an appraiser flexibility to either state that the report is an appraisal report, again, big A, big R, or a restricted appraisal report, or state that the report is intended to comply with the requirements of Standards Rule 2-2A or 2-2B if they use a different label. So if you call it something else, but you say it's your intent to comply with Standards Rule 2-2A, then you are effectively producing an appraisal report using those minimum reporting requirements. And as noted here, the failure to label the report using the word appraisal does not exempt an appraiser from adherence to USPAP when either the service or the appraiser is required by law or regulation or agreement with the client to comply with USPAP. Now, the ASB is seeking feedback from stakeholders on this topic, but we hope that this proposed change would preserve the integrity of the two reporting options for those folks who need them, while providing the flexibility to not use the word or label appraisal in the report.
Would this make it easier for appraisers to complete evaluations for financial institutions?
Well, given the importance of the topic and the amount of time we spent on this, the ASB is certainly seeking feedback on the issue, but in a nutshell, yes, we believe so. The current USPAP requirement that an appraiser label a report as an appraisal report or a restricted appraisal report seems to be the primary sticking point preventing appraisers from completing an evaluation.
Thank you, Wayne. And actually, just a real quick note for our listeners, for the purposes of this webinar and on this and the next few slides, we're only going to display the proposed changes to the wording for Standards Rule 2-2, but the exposure draft includes the parallel changes for Standards 8 and 10. So let's move on to slide number 9 in the deck here. What other revisions is the ASB proposing to Standards Rule 2-2?
Sure. Well, the changes noted on this slide are really a continuation of the rewording of the introduction to Standards Rule 2-2. So beyond the proposed change to labeling, the ASB believes the rewording of these introductory paragraphs improves readability and understandability, but frankly does not represent a material change to the requirements. So as indicated on this page that you've displayed, since we're proposing to begin Standards Rule 2-2 with the statement, the content and level of information provided in appraisal report must be appropriate for the intended use and the intended users of the appraisal, the statement does not need to be repeated at the beginning of the content requirements for each report type.
Okay. It looks like if we move to slide 10 here, this includes additional language proposed for the deletion regarding Standards Rule 2-2, as well as 8-2 and 10-2. Can you tell us a little bit about this potential change?
Certainly. Well, first off, let's remember that an intended user is one who is identified as such by the appraiser in the assignment and in the report. So stakeholders have expressed confusion regarding the current wording of this comment, which sets forth a specific incidence when a recipient of a report does not become an intended user. So the wording of this comment could imply that there are cases when a mere recipient of a report does become an intended user. So this proposed deletion is designed to enforce the concept that just because a party receives a copy of an appraisal report or a restricted appraisal report, they do not become an intended user. Again, they must have been identified as an intended user by the appraiser as a part of the assignment.
That makes sense. Can you also now, Wayne, give us a quick overview of the proposed changes in this exposure draft associated with signing the appraisal? Signing the certification?
Certainly. Well, I'm certainly happy to do so. So as noted here, again, the overview page here, there are 3 areas in which changes are being proposed. So the first one is clarification as to the nature of a signature. The second is an administrative edit to make the wording similar or consistent in this section along with other parts of USPAP, and an edit to the comment for consistency with the scope of work rule disclosure obligations.
Why is the ASB proposing to amend Standards Rule 2-2B and the parallel standards rules for personal property and business appraisal regarding the nature of the signature on the certification?
Well, Lisa, this is considered a necessary change to USPAP due to the continued evolution in the delivery of appraisal results to clients and intended users. So back in the day, a signature was literally a wet signature. That's one with pen and ink made by the appraiser at the bottom of the certification within a printed, bound, hard copy, or more than likely multiple hard copies of an original appraisal report. Things have changed. Within the current version of USPAP, the definition of signature is personalized evidence indicating authentication of the work performed by the appraiser and the acceptance of the responsibility for content analyses and the conclusions in the report. So with the continued technological advancements in the electronic delivery of appraisal assignment results, the concept of a signature continues to evolve. And the wording proposed by the ASB is designed to accommodate these changes.
That seems like a good change to me. I remember the days when I used to sign the reports and then drive them to the clients. Let's look at slide 13. This seems to reflect a minor change in our wording. Can you provide our listeners with the background for this proposed change?
Well, Lisa, you're absolutely correct. This is essentially a cleanup item. So the clause is required to is used in Standards Rule 2-3, subsection C, subsection I. However, elsewhere in USPAP, the term must is used. So this change essentially makes this rule consistent with the requirements in other parts of USPAP.
Okay. Let's see, moving on to slide 14, what additional changes are proposed in Standards Rule 2-3C and the parallel standards rules for personal property and business appraisal?
Right. So the changes here are changes to the comment to 2-3C2 with regard to disclosure of significant appraisal assistance. So let's remember, first off, that the name of anyone providing significant appraisal assistance must be stated in the certification as per Standards Rule 2-3A, right? That's our certification standard. However, the proposed change to this comment parallels the wording of the disclosure obligations section of the scope of work rule and indicates that the extent of the assistance by others may be disclosed in any parts of the report. You know, we get questions sometime about, do I need to put the extent of the assistance or the nature of that assistance in the certification? There's no prohibition, but it could get a little wordy. The point here is you don't have to have a section of your report called scope of work. You can disclose that assistance as needed, but you must disclose it within your report wherever you'd like.
Okay. Okay. Slide 15 indicates that the Appraisal Standards Board is proposing changes to the disclosure section of the scope of work rule. Can you tell us about those?
Well, certainly, you know, as we'll actually learn on the next slide, both of these proposed changes impact a comment in the disclosure obligations section of the scope of work. And, you know, the first one is an addition and the other one is a deletion.
Okay, well, let's get the details on this on slide 16.
Well, let's see. The proposed changes include, well, the first one is, as I noted, an addition. So this is some additional wording. The intent of this proposal is to help interpret the scope of work disclosure requirements by clarifying that in some cases it may be appropriate to explain the level of inspection that was performed. So given the current changes and the multiple options available to appraisers on how to perform inspections, it's important for appraisers to communicate clearly so the client and any other intended users are able to understand how the inspection, if any, was performed and by whom. And the second proposed change is actually a deletion of the statement. Proper disclosure is required because clients and other intended users rely on the assignment results. So I'm gonna depart from this for a second and say that, you know, you encourage during your introduction for folks to send us comments. And I will tell you that this is a crystal clear example of a well-placed comment by an individual commenter that the ASB really took to heart. You know, we received a comment by a stakeholder. Actually, it was from the first exposure draft questioning why this type of explanation is considered necessary only in the scope of work rule. And after considering the matter, the ASB proposes actually to delete this portion of the comment. The alternative, of course, was to put this sort of comment everywhere throughout USPAP to enforce the importance of all matters within the requirements. So essentially, given that an appraiser is required to understand who the intended users are and what the intended use is of the appraisal, this comment seems redundant.
Yeah, and I would also like to thank that person for saying that comment. And I know as you said, the Appraisal Standards Board takes comments very seriously, and sometimes just one sentence from one person out of the blue can make all the difference. So they're very important that you send us your comments. Let's move on here. Wayne, what are some of the revisions to a few of the existing definitions? And isn't there a deletion of one as well as a few new definitions being proposed in the second exposure draft? Can you just briefly cover those potential changes?
Certainly. Well, we'll call this our summary slide here. So as the slide notes, there are 3 definitions that are proposed to be revised, 1 definition that is proposed to be deleted, and 3 definitions that we propose to add.
Okay.
We'll dig into the details later.
Here, I guess it's later. So
all right.
what revisions are being proposed to the existing definitions?
Sure. So the first definition proposed for revision is the definition of appraiser. So in the current 2020-21 version of USPAP, a revision was made to this definition. Essentially, it was the deletion of a comment. And this made some stakeholders feel that this unintentionally broadened the definition to encompass a whole host of non-appraisers who may have something to do with a transaction or a deal or a sale, who may be acting competently and independently. So the ASB does not really agree with this broadened interpretation, since we deleted this comment after looking at the preamble to USPAP, which contains information that clearly indicates when USPAP applies. Nonetheless, the goal is for USPAP to be readable and understandable and enforceable. So the ASB is proposing the noted revisions to this definition in an effort to address stakeholders' concerns. The next definition that is proposed to be revised is assignment elements. And the key addition is the phrase "such as" when describing the assignment elements, which indicates that the list of items which follows may not be all inclusive, and also allows this to apply to both appraisal and appraisal review. And finally, the definition of personal inspection is proposed to be revised. And during the last cycle, there was a lot of discussion while we were talking about hybrid inspections and so forth, about the nature of an inspection. In the current edition of USPAP, we had adopted some changes to Advisory Opinion 2, which dealt with the topic of personal inspection. In fact, there have been some, during this virus crisis, we've had some Q&As that we've put out involving the nature of an inspection, et cetera. So again, this was a new definition that was added to the 2020-21 edition of USPAP due to this evolving nature of inspections, including who completes them, how they're completed, what does or does not constitute a personal inspection by the appraiser. So effectively, as a new definition, we received some feedback after the fact. This is from some USPAP instructors, some folks who really take a hard look at USPAP. We have some USPAP scholars out there. And the ASB felt that, based on some of this commentary, additional clarifications were needed to this definition.
That's really helpful background. Thank you for that, Wayne. Now, it looks like you are proposing the deletion of the definition of misleading. Can you tell us about that?
Sure. Well, the ASB, again, receives information through a lot of sources. And, social media is another source that's out there. While we don't hang on every word of everybody's blog post, there were some very, very informative and I guess I'll say cogent observations made by some stakeholders with regard to this definition of misleading. So during the last cycle, again, we made changes to USPAP to clarify, as a part of the competency rule, that perfection is impossible to attain. However, some stakeholders have expressed concern that, based upon the definition we have about misleading, that a simple typographical error could be viewed as misleading. So after careful consideration, the ASB notes the following. First off, the conduct section of the ethics rule prohibits the appraiser from communicating results with the intent to mislead or defraud, and from allowing others to do so, right? And the development standards, those are the odd number standards, 1, 3, 5, 7, and 9, address the appraiser's responsibility to not commit a substantial error of omission or commission that significantly affects an appraisal. So in light of that, the ASB has concluded that the appraiser's responsibility to avoid errors of both commission, right, that's intent, and omission, that would be errors, are clear, and therefore the definition is not needed.
Okay, that's great. Now, what are the new definitions that are being proposed by the ASB?
Well, certainly. Let's go to that page here. So first off, as we note, there are three definitions that are proposed. The goal here is to provide context as to the meaning of these terms, which are included in USPAP and the guidance, but are not currently defined. So as you know, Lisa, the ASB often gets questions about significant appraisal assistance. What is it and what is it not? The proposed definition here seeks to clarify what the term means in USPAP. Also, state and summarize are used throughout the reporting standards, but have not been defined. And we are seeking to clarify the difference in the amount of information to be presented in each instance. I want to note a couple things. First off, relative to the first exposure draft, the proposed definition of state, the term state, is unchanged. However, there have been minor edits to the proposed definitions of significant appraisal assistance and summarize compared to the first exposure draft. So if you're playing along on the home game and you read the first exposure draft and you now see that we're still proposing these new definitions, you'll want to compare the first exposure draft and the second exposure draft changes so that you know what the current definition proposal is. Finally, and I'm going to touch the third rail here a little bit here. I should also note that in the first exposure draft, the ASB proposed to define the term evaluation. To be honest, after receiving feedback from many sources, the ASB has decided not to include a definition of this term, as it is primarily referred to in guidance rather than in the USPAP rules and standards. So Advisory Opinion 13 has long addressed evaluations, and the context for the use of this term in Advisory Opinion 13 is clear. So as with all sections, just to kind of wrap up the definition section here, as with all sections of the exposure draft, the ASB is interested in hearing from stakeholders on the above proposed changes, as well as any other terms that folks feel should or should not be defined in USPAP.
Great. That looks like we are down to our final topic. Can you give us a quick overview of the proposed changes that we kind of label other edits?
Certainly. As noted on this slide, which I think is 21, yes it is, there are three areas in which changes are being proposed. The first is the addition of the word transfer to the section requiring analysis of prior subject sales. The second is really an administrative edit to make the wording of Standards Rule 8-2B consistent with the parallel section of the same standard. And finally, the removal of a comment which repeats an existing requirement under the scope of work rule.
Okay, great. That's a good rundown of the three topics you'll discuss. Can you look at that first one and tell us what revisions the ASB is proposing to Standards Rule 1-5B with regard to prior sales of the subject property?
Certainly. Well, as you know, Lisa, the ASB receives a lot of questions regarding the analysis and reporting of a property's history, in particular its sales history. In fact, Advisory Opinion 1 is dedicated to this topic, and there are a number of FAQs as a part of the guidance to USPAP. So a lingering question in the real property arena specifically is the topic of transfers of properties that are technically not sales. So for example, a transfer of a property from a former owner to a lending institution via a deed in lieu of foreclosure. So last year, the ASB actually issued a Q&A about this topic, and we offered guidance wherein we said, yes, Standards Rule 1-5 applies to a transfer of real property. Many appraisers actually, have taken this in stride and frankly have been analyzing and reporting transfers as a part of the subject history for many years. However, several stakeholders pushed back, and they pointed out that 1-5B doesn't specifically require that transfers be analyzed. The ASB believes that, after considering the rationale behind the requirement to analyze sales history in general, the ASB is proposing this revision to 1-5B, as well as the companion references in 7-5 for personal property and 9-4 for business appraisal, to require the analysis of transfers when such information is available in the normal course of business.
And it looks like slide number 23 refers to kind of the same general topic as slide 20. What is different?
Sort of. Let's see. So let's see. 20. Actually, we should have said 22. I think. Anyway,
20, I'm sorry. It says 22. You're right.
That's a typo on my part somewhere. These things happen. Perfection is impossible to attain. The proposed revision noted on slide 23 actually involves Standard 8, personal property appraisal reporting. This proposed revision is actually intended to make the language of 8-2B identical to the current language in 8-2A to help clarify that there is no difference in the requirements. To be honest, I'm gonna open the green curtain and let everyone see behind into the land of Oz. We missed this, frankly, as we were making edits last time. It should have been consistent. It's now time to fix it. I'll also note here that the additional proposed language that we're showing on the screen includes the end transfers information that we talked about previously. And then finally, one thing I would like to note is that the requirement to analyze sales and transfers in 7-5 for personal property differs from 1-5. The requirement in 7-5 applies only when necessary for credible assignment results.
And finally, just tell us about the deletion of the comment in Standards Rule 2-2, 8-2, and 10-2.
Certainly. These respective comments to disclose the scope of work repeat a requirement that already exists within the comment to the disclosure obligations section of the scope of work rule. As such, this is a redundant comment, and we're proposing to remove it from the reporting standards rules. Furthermore, as full disclosure, on the same vein of perfection is impossible to attain, while preparing for the webinar, I did note that for consistency, this same comment appears in Standard Rules 4-2G and 6-2G. Those are the reporting standards for reviews and mass appraisal. So depending upon stakeholder feedback, if we continue to propose deletion of this comment as noted, the next exposure draft will include the standards 4 and 6 references as being proposed for deletion as well.
Thank you, Wayne. And now it's time to let you know we always want to hear from you.
Right. So, the point I want to make here is that the ASB operates in a very open, transparent manner. We are genuinely, and I want to say genuinely, again, interested in hearing what appraisers and clients and regulators and members of the public have to say about USPAP in general, and in particular about the proposed revisions. So we really urge you to please respond to the exposure draft and tell us what you think. As noted on this slide, written comments are due by July 30th, and that's immediately prior to our July 31st virtual public meeting. We wanted to give folks a full 60 days to get comments in. We know that it's A, summertime, and B, An interesting time with the country being partially still closed down and partially opening back up. We would urge you to please send us your comments, and also to sign up for the live stream for that July 31st virtual public meeting. I believe Aida has sent a link through the system to enable you to sign up.
I did see that link pop up earlier. It is in the chat box, but you can always find it on the foundation website as well.
Sure.
Thank you, Wayne, for all this information. And while you have been talking, I've been busy watching the questions being proposed in the chat box, and also I've received some other questions here via email. So I'm just going to quickly look through them. You had mentioned earlier, you know, a common topic is significant appraisal assistance. I have kind of a two-part question here. It looks like a pretty good one. It says, if the client gives me a copy of an appraisal report that was done previously by a different appraiser to use while I complete an exterior only appraisal, is that considered significant appraisal assistance?
Well, that's an interesting question. What I will say is, if we were to rewind a few pages and look at the proposed definition of significant appraisal assistance, it actually kind of gets to the heart of this issue. You know, the prior appraiser didn't provide this direct assistance to you, if you are the one doing this, in support of the current appraisal. So no, you would not be required to name that prior appraiser in your certification. However, you know, in your disclosure of your scope of work, you should disclose the sources that you use to describe the subject property, you know, whether it's strictly this appraisal or, you know, some other materials that you use.
Okay. And then here's the second part of that question. Since the appraisal was completed by another appraiser and provided to me to use for information of relevant characteristics, do I need to get permission from that appraiser to use their information?
Well, my answer would be no. In this case, you know, the prior appraisal is general information being provided to you. This would be similar to maybe a market study, an offering memorandum, maybe an environmental site assessment, which, you know, may provide facts and figures and opinions about the subject property or the market. It would be up to the appraiser who's doing the current appraisal to adequately describe the subject property, to take in all of the facts that they've been able to collect and opinions that they've been able to collect in order to produce credible assignment results.
Okay. And I have a third question on significant appraisal assistance, but this one kind of has a twist to it.
Cool.
Yeah, twist. It's kind of the opposite of what we hear, but it's a good question. Can an appraiser trainee not provide significant appraisal assistance? It's kind of the opposite of what we always hear.
Can they not provide significant appraisal assistance? Well, presumably they could if they're merely providing what I'll call administrative or clerical type tasks. You know, holding one end of the tape measure, you know, back in the day when you used to measure things without using lasers, but holding one end of the tape measure does not necessarily constitute significant appraisal assistance, or merely typing something up, or you know, if you were producing hard copies, taping down photos. Those are, just because one happens to be an appraiser trainee, they may not in all instances be providing significant appraisal assistance.
Good answer. This next question, I know we had this one in one of the board meetings maybe within the last year.
Oh, excellent.
Yes.
I wonder how I answered it then.
Can an intended user request that their name not be included in an appraisal report, similar to how a client is not being named, so long as their name is included in the work file?
Yeah, I'll say it depends. If it is an appraisal report, an intended user can be described by type. They don't have to be named. If it were a restricted appraisal report and you are a non-client intended user, a strict reading of USPAP would prohibit the non-disclosure of the additional intended user.
Okay.
So you better make sure you've had the client order an appraisal report and that you are comfortable with being disclosed as a type of intended user as opposed to a specifically named intended user.
That sounds like exactly how you answered it last year, Wayne.
Okay.
Okay. We back to significant appraisal assistance again. In this section of significant appraisal assistance, how does this section relate to information provided by non-appraisers, office assistants, etc.?
Yeah, again, you don't have to be a certified or licensed or trainee appraiser with a credential in order to provide significant appraisal assistance. That's a, you know, in some states there is no trainee program, but people are hired and they provide significant appraisal assistance. If they are acting as an appraiser, if they're expected to perform independently and competently, etc., they provide you with significant assistance that affects your assignment results, then they can act as an appraiser and they are providing significant appraisal assistance. You know, the corollary to that question is, what about somebody who just provides information that you use, who is not an appraiser, isn't acting as an appraiser, doesn't intend to be an appraiser? So if I am an environmental engineer and provide an environmental site assessment, that goes to the appraiser, and the appraiser uses, let's say, cleanup costs that are embedded in that report. Is it necessary to name that person in the certification as providing significant appraisal assistance? The answer is no. However, there is no prohibition on you saying that you relied on information from from this environmental report in your certification. You would certainly disclose this in your scope of work. If you make a hard deduction for certain costs, you're going to want to source that cost somewhere for the client and intended users to understand.
That's actually a really good explanation. I know that's a pretty common question, so thank you for that, Wayne.
Yeah, one thing I want to follow up on it. There, you know, USPAP says that you are required when you have an appraiser helping you on an assignment and they provide significant appraisal assistance. You must disclose who they are and what they did. There is, people need to remember, there's no prohibition anywhere in USPAP for anybody disclosing someone else's assistance. You know, now, what we wouldn't expect is, by virtue of someone taking a USPAP class, that suddenly the USPAP instructor gets, honorable mention in every appraisal that somebody does. That's not the expectation here, because significant appraisal assistance should relate to your specific assignment. That being said, if someone who's a non-appraiser provides information, then it's up to the appraiser to choose to disclose who they are. The level of importance of doing so is probably something an appraiser wants to consider. And, if it's really germane to the description of the property, or again, a situation where you're making a deduction or relying on a construction cost estimate or something like that as a part of the scope of work, you really need to do so. I'm sorry, belaboring the point.
No, it's great. This is a very important topic, and I know I get a lot of questions about it, so I think it's good that you gave us some more information. I'm going to change topics, and I'm actually going to ask you this question. Someone asked it, and it kind of technically is more of a qualifications question, but I know that since you were the prior chair of that board, you have a good way to answer this. Due to the decrease in in-person live classes, I'm considering taking more online classes. Can I take this 15 and 7-hour USPAP classes online?
Well, that is a multi-part answer, I guess I'll say. So first off, both the 7-hour USPAP update course, this is a continuing education course, right, that appraisers who are licensed or certified have to take, as well as the 15-hour USPAP qualifying education course have for many years been offered online. So we have, course providers that do offer these courses, and, these are typically asynchronous classes. That is, you sign up for the class, and if it's 2 in the morning and you want to take a class in your jammies, you go ahead and do so. You work on it at your own time and pace. You can, reach out to the instructor, etc. But that being said, I would urge our listeners to check with the course provider and with their state appraisal board to ensure that the course is approved in your state. So if you're going with a national online provider of coursework, generally they're going to show you their approval in a particular state. It's going to have an end date when the approval expires. But you've always been able to, to take asynchronous, and in some cases, synchronous courses that have flowed through the normal IDEC approval process for USPAP. So the current environment, there are challenges, right? As noted in the question, there's some challenges on holding in-person classes due to the virus. So the AQB has been working with the appraisal subcommittee, and the appraisal subcommittee has issued guidance to states allowing for continuing education to be offered online. This is synchronously, so live, right? Subject to certain rules. The instructor has to be able to see the students have to be able to see the instructor, etc. And they have to check attendance, etc., etc. So now there are some states where they have temporarily amended their rules. And in those states, the 7-hour USPAP course can be taken live and virtually, sort of as if you were sitting in the class, but doing so in front of a camera. It's my understanding, frankly, that the AQB encouraged the ASD, and the ASD approved these offerings, or the ASC, I should say, encouraged states to approve these types of offerings on a rolling 90-day period. One thing I will say is that the guidance does not apply to qualifying education courses. So a typical classroom offering of the 15-hour USPAP course cannot be offered in this virtual format at this time for qualifying education.
See, Wayne, I knew you could answer the question. That's just
the
depth of your knowledge.
My AQB gathers dust at times, so that's why I could pull it out.
Just a couple more questions, just kind of a follow-up. Go back to that trainee where, can the trainee provide, assistance that is not important? And I think what they're asking here is kind of the word trainee as it relates to a significant appraisal assistance. What does that word, being an appraiser mean in that terminology? Because it doesn't say significant trainee assistance. So I think they're just wanting to understand what it means to be an appraiser.
Right. Well, if we look at the definition of appraiser, if someone is expected to act, independently and competently in an unbiased manner, they're providing, appraisal services. They're part of the appraisal assignment. They're contributing to the, meaningfully to the process. So there is a difference between someone saying to a clerical person or a trainee, go to the electronic repository of sales that have occurred and download everything that's sold in May. That's one thing. If you say, go find me 5 good comps, meaning you're using appraisal judgment to determine that some of those sales, that batch of sales that occurred in May, are better than others, that may be comparable, that may be used within the appraisal assignment, then you have begun to provide significant appraisal assistance. It is not dependent upon the license that you hold or whether you have business cards that say you're an appraiser.
Okay. On that same topic of the kind of the definition of appraiser, I have a question here, and I'm not sure we have everything we need to answer it, so I'll just throw it out there and you go with it, Wayne, see what we end up, see where we end up.
Right.
With the proposed revisions to the definition of appraiser, i.e. engage in appraisal practice, has there been any feedback from states on how that may impact their laws pertaining to individuals who hold or do not hold a credential in their state?
Well, to be honest, we have received about, and Aida, who is behind the scenes and is our on-staff person who makes these things go, probably could tell me what the number is, and maybe you can, Lisa. But we have received some feedback. I have not studied it to see all of the sources, and I'm curious myself about the impact of this definitional change on state law, which varies. Some folks just say whatever it says in USPAP is fine. Other states have a very specific definition that they use for appraiser. And frankly, there's been a bit of a departure in those states from the definition in USPAP all along. So this may just be a continued difference.
Okay, great. Thank you. I will ask you one more question, and that is there any guidance available from the ASB regarding inspections during the coronavirus?
Well, yes. In fact, between, I guess I'll say mid-March and early May, plus or minus, the ASB actually issued 4 inspection-related Q&As. And 2 of these are very directly related to real property inspections. One is directly related to personal property inspections. And the 4th one is, I guess I'll say, indirectly related to inspections. It came out effectively simultaneously with the GSE guidance on their modified process that allowed for exterior only appraisals or desktop appraisals associated with some transactions or circumstances. So I would urge anyone to pop onto the Appraisal Foundation website and download those Q&As if they don't already have them.
Okay, good, perfect. One more question just popped up. Do you want to do that one too, Wayne?
Okay. We've got at least 8 minutes before.
Okay, good. This should not take too long. Do appraisers, not necessarily licensed appraisers, I assume by that they also include certified in that, so they're probably referring to anybody that holds a credential. Do appraisers who do not have a credential have to comply with USPAP reporting?
Well, again, there are circumstances when an appraiser is required to comply. Right. So if the nature of the assignment, if there are federal legislation or state legislation that says you must, when completing this appraisal, comply with USPAP, then yes, you have to comply. If there's a state regulation that requires you to, then you have to comply. If you do hold a credential and you're in a state where it says if you complete an appraisal that you must comply with USPAP, then you must comply with USPAP. If you have a client and the client hires you and says, I require that when you complete this assignment that you comply with USPAP, then you have to comply with USPAP. If you are an appraiser, or if you are a person who is not licensed and not credentialed, you don't belong to an organization of appraisers that requires you to comply, there's no law or regulation or agreement from a client, you can still comply voluntarily with USPAP. We feel it gives you a pretty good set of ethics and rules and standards to follow, but you may not have to.
Okay. And I know I said that was the last one, but I did find one more in here.
It's okay.
And I'll quit looking. Okay. What happened to the proposed changes to the reporting of exposure time?
Did we change exposure time in the first exposure draft?
I didn't think so, but I wanted to check with you.
I will have to study that. I don't recall there being a proposed change to exposure time.
Yeah, I'm thinking that may just be a general question, maybe not related to our actual exposure
Right.
graphs. Yeah, okay,
Yeah.
that's fine.
I don't recall there being an active plan to change the nature of exposure time.
Yes, I agree with you. Okay, Wayne, that is it. I promise I will not ask you any more questions, but as usual, you are incredible at doing so, and it's probably why you get so many good questions on these webinars. Thank you, everybody, for coming here today. And again, we cannot stress enough how important it is for you to contact us with your comments, be those comments 1 sentence long or 50 pages long. We definitely have people who send very lengthy comments. They are read absolutely every single word. So please send those to us. You have our contact information there on the screen. And again, I just want to thank everybody for coming today. Any final words from you, Wayne?
I just want to thank you. You did a great job. And thank you, Aida and Joellen, who are our silent staff members participating behind the scenes.
Absolutely. Can't do it without them. Thank you all. Have a great day out there and enjoy your week.
Thanks.